have any income, and I just sold my car for $350 just so I could get some money to complete.
Tell me how you were denied access to a fair hearing.
Because I was given a court date. I was in jail, and they just gave me a surprise court date one morning, and I didn't know I was going to court, and they just had a recommendation for me to be either take it and get out or take a chance on sitting there, and I needed to get back to my...
Before this hearing even begins, you can already feel the tension in the courtroom. A probation violation hearing might sound routine, but make no mistake, this is the moment where a judge decides whether someone keeps their freedom or loses it. And today, the defendant is about to learn a brutal lesson about something judges value more than excuses: accountability.
Doctor and get seen about so I could get my... Luckily, my doctor said if it had been any longer, I would have lost my leg from just below my knee. And my next appointment is the 16th of this month.
And you're saying that set of facts you just provided is the basis for your statement that you were denied a fair hearing?
It was at this moment that she knew. She fucked up.
Yeah, that I was I could sit there and wait, I guess however long it would have taken. I was there almost 4 months.
You were in on 4 months without a hearing?
Yeah, I was there for 4 months. I didn't have a hearing.
That sounds extraordinary.
Well, I didn't have a hearing. I just was given the recommendation, and I was told either I could take it or not. But I could get out that day if I took it. So against my better judgment, I didn't want to take it because it was extensive, knowing I didn't have a job and wasn't going to have a job for a while. So I just bit the bullet and took it so I could get out and get back under doctor's care.
Okay, but that sounds like a strategic decision you made. That doesn't feel like somebody has said something that denies you a fund.
Well, no, I didn't say I was denied one. I was just saying I didn't have a hearing.
You said you were denied access to a fair hearing. I mean, we can have Terry quote it back, but I mean, you said you were denied access to a fair hearing.
What I meant was I didn't have a hearing before I was given that recommendation.
I mean, because what I just heard was that as a courtesy to you, they pulled you early and offered you a consent order.
Yeah, because they weren't, I had to give an MRI for my foot, and they sent me to the hospital, and my insurance wouldn't pay for it. So that next morning actually is whenever I was given this recommendation to get out. And I'm still under care of my...
That single word, I admit, just changed everything. In legal terms, an admission to probation violations means the court doesn't need a trial or evidence. The violations are already established. From here on out, this hearing is only about one question: what should the punishment be? And the judge now holds all the power.
My surgeon, she hasn't released me yet to be able to walk back on my foot fully yet.
I mean, you're coming in here, but I need to say out loud, these are not nothing cases. 25 SR 837 is a battery family violence.
Right.
It's one of the highest, please don't interrupt me. It's one of the highest cases that we have. 25 SR 846 is a simple battery under the Family Violence Act, which is also one of the more serious cases in this court.
Well, if you look at my record, I haven't had any charges, or I haven't never been convicted of any simple battery. The last time I was charged with that was the last time I was married. I've been divorced since November 27, 2011. I haven't had any charges, and honestly, this relationship I've been in has been abusive for the last 10 years, and that was the first time I called the police on him, and then I ended up going.
Okay.
I mean, you can look at my criminal record and see that I'm not a battery person. I haven't never been convicted of any battery at all. And this just caught me at a really bad time to where I can't, do anything to help myself in this situation, and I don't have anybody to turn to help me with money. And if I have to go, if I could please, possibly go on the weekend so I could still get to my doctor's appointments.
Okay. All right, ma'am, anything else you want to tell me? I'm
just worried if I have to go, what am I supposed to do? Like, I don't I won't be able to get to my doctor, so how am I going to be able to know about the condition of my foot? And
Spalding County inmates are provided medical care.
yeah, I'm well aware of that.
Okay. Anything else, ma'am?
No, sir.
Okay. So so the evidence is closed. Miss Plunkett, what I need you to know and why you're sensing like frustration from me is I kept waiting to hear you accept any level of responsibility. And I heard no.
No, I'm sorry.
I gave you a full hearing. I circled back to you on several occasions and said, is there anything else you want me to know? So that was not an invitation, ma'am, for you to interrupt me and tell me your opinion about my opinion. Your opinion of my opinion is irrelevant to me. Are we clear?
Yes, sir.
So I'm going to be quiet now, and you're going to tell me all the rest of the stuff you need to tell me, and then I'm going to talk. Go ahead.
I'm just nervous. I apologize. I don't really know what else to say right now.
Okay. Anything else you want to say before I start talking and you agree not to interrupt me?
I just put myself on the mercy of the court.
Okay. Last chance. Anything else?
And I'll take full responsibility for everything that was said. I didn't mean to ignore that or put that off. I'm just nervous. I'm sorry.
Okay. All right. Anything else before I do my talking?
No, sir.
Okay, so now you're going to be quiet and I'm going to talk. Fair enough? Mm-hmm. All right. That was a yes.
Yes, sir.
Okay.
This is where things start going sideways. Instead of focusing on responsibility for missing probation requirements, the defendant begins explaining circumstances and hardships. Now, those issues might be real, but in probation hearings, judges are usually listening for something very specific: ownership of the violation first, explanation second. Without that order, the message can come across very differently than intended.
Again, I kept waiting for her to accept responsibility for anything. I mean, she did admit to the violations, but I kept waiting to hear how she was going to make these things right. And instead, I heard a litany of that she was denied access to a fair hearing, she was called up and caught off guard, and I'm looking at these documents. So each time you're referencing an event that happened in your life, there was a piece of paperwork that was created from that event. And I'm looking at it. And I'm looking at that you were represented in this case. You were represented when you entered this plea. And in both cases, and I'm addressing both cases. Let's just I'm just addressing both cases. Oh, you want to talk again? You go right ahead, ma'am. This is clearly your turn to talk. Go ahead.
I'm sorry.
No, say whatever it is you want to say. You clearly need me to understand something that you don't think I understand.
I apologize, Your Honor.
No, go ahead. I will wait.
I just keep messing up. I'm sorry.
Yeah. That's exactly what is happening here, because I have spent this whole morning, at every break, looking at your case and trying desperately to find a way not to go to jail. I need you to understand that since 9 o'clock this morning, I have looked at your case no less than 3 times, trying to find a pathway for me to feel comfortable as the judge of this court to not put you in jail. And I was desperately hoping you were going to come in here and say from the very beginning, I have full responsibility here. I did not do the things I should have done. I understand that I have responsibilities here that I didn't do. But I heard you repeatedly say that we're trying to get money out of you that you didn't have. Well, we're a $0 court. Everybody in this court, except restitution, can work off their fines with community service work, or is unable to work, can get their fees waived. You know, everyone here who has medical issues, we deal with that. We know what to do with that. We know how to help people. We have all kinds of folks who come in here and do their community service work in the very comfortable chairs in the back because they can't go do physical labor. We meet people where they are. And for you to come in here and say that you are denied access to this court because you are caught off guard is disingenuous on its best day, because what I heard was, as a courtesy to you and out of respect for the fact that you were incarcerated, you were given an opportunity to sign a consent order back.
Right here is the turning point. The judge basically reveals what he's been waiting for the entire hearing: accountability. In probation court, admitting the violation isn't always enough. Judges often want to hear that the person understands why the rules mattered, and what they plan to do differently.
Back on November 20th, or somewhere there close to. The warrant, which you said you were incarcerated for 4 months, that makes no sense to me at all, because the warrant that was issued, that you signed the consent order on, was issued on October 8th of 2025, and the consent order was signed a month and 12 days later on November 20th. So this fact that you stayed incarcerated for 4 months, it doesn't even exist in my file. The list of... Go ahead. Go ahead. Go ahead. What is it you want me to know?
I forgot about the warrant. That had something to do, I don't remember exactly, but that was lifted. Something to do with Miss Rich. I don't remember the whole spiel of it, and I'm sorry. I'm so nervous. I'm just messing up. I just need to be quiet.
To be fair, that is exactly what I asked you to do.
Yes, sir.
If I might just be very clear, I gave you all the time you wanted to speak, and then I asked you to be quiet and let me speak, and you have utterly failed to do that at every turn. I don't see you as a candidate for probation. I don't see any pathway where this gets any better. I don't see any pathway where this works. And given the fact that this is not the first warrant on this case, and it's getting worse, I don't think this is a relationship we should keep. So, I'm revoking both cases.